Good afternoon once again. We have a fantastic panel here today. Industry leaders from different fields. We have Dr. S.K. Murthy, Patent Counsel from Intel. We have Dr. Mahendra Thakre, Senior IP Counsel for VIATRIS, Mylan, Dr. Sridhar Prasangi, and of course we have Dr. Shamim, Ahmad. So we have a very wide representation from industry here, and it is, I know that, Bangalore is one of those epicenters of IP knowledge in India. It's always makes me nervous to come and speak and address the audience in Bangalore, because it's really everybody is so knowledgeable. But to have a panel like this here, it's amazing. Now I have no industry experience. I'm only been practicing as a patent lawyer for 40 years. But I must say that when I write a patent specification, when I prosecute a patent application, when I preside over, when I argue an opposition matter, or when I go to the court, I must say that about 70% of my knowledge comes from gentlemen like them sitting here. Their instructions are awesome because they have knowledge which is really from the ground level to an incredible amount of knowledge of what they want for the future. They have experience in working right from the innovation stage to meet the demand of the market needs, to keep innovating, to keep being ahead of the competitors, to protect their inventions in multiple jurisdictions with multiple kind of law, with different counsels across different cultures and barriers, and then make sure that they are the common glue that binds the whole entire global prosecution together. And as a lawyer, I am aware, I've been pulled up a few times myself for doing something which I thought was brilliant, but which may have been brilliant in that particular context, because sometimes we try to work with a myopic vision, but counsels like them, in-house counsels, they know that if what happens here could have an entirely different kind of connotation and ramification in different jurisdictions. So for them, they make sure that every single decision that they take, every single bit of instructions that they send to counsel like us is not with respect to a single point agenda of winning or losing that particular case, but with the global implication in mind and future in mind. So what we are going to do is, I'm going to let the panelists take over. We'll ask them questions. We'll try to make it as interactive as possible. While we are talking, while the panelists are saying, after they spoke about any matters they have, any points they wish to make, you may also raise your questions simultaneously. We'll try to make it as interactive as possible. So thank you.
We have realized that after the IPAB was abolished and the appeals started going to the High Court, in the last 2 years, we have had the Delhi High Court and Chennai High Court setting down law correctly. So many bad precedents of the patent office have been set right. So, would you recommend, therefore, even if it means investing more money, but on a case which is not very economical for you really from the market point of view, but purely in order to get a good precedent, want to prosecute an application, if necessary, take the matter to an appeal to the High Court?
Definitely yes. If it can set a good precedence and if it can set the law straight, definitely yes. Why not? There should be somebody who should build the cat, and if we could build the cat, why not?
And this is a question addressed to 3 people from Pharma.
I did not call anybody cat, but I just reference.
So there's a question that any of the people, other 3 members are all from Pharma field. We have had this famous VIATRIS case and AstraZeneca, various cases in the High Court, where there's a conflict between too much of disclosure and the scope of the claim, coverage versus protection. That often happens when you have a Marcus claim. So you have a Marcus claim which talks about, which is practically claims every subsequent, although examples may be restricted to only one or two of the derivatives. And that would actually, in many jurisdictions, that would give you protection to enforce against anything that falls under the Marcus claim. Then you have a subsequent case, a second case, which is for a specific derivative. So the question always arises, because you enforced a broader claim against an infringer who used a subspecies of that Marcus claim, would your second patent be invalid? Because on one hand, we are talking about the fact that my earlier patent covers everything when the question of infringement arises. But the question of obviousness arises, my second patent is not obvious because of the first patent. So have you faced such issues yourself ever in any jurisdictions?
Yeah, so this is very common issue with respect to the pharmaceuticals, because just for the crowd perspective, just I would like to say that Marcus structures means in chemical patent, we develop a series of compounds. Suppose there is one particular chemical formula. So we try to put a different groups, and then probably a single formula can represent, you can say, the millions of compounds. So that's how we represent, because millions of compounds very difficult to put into the patent and then describe. So that's the way wherein we generally define our chemical inventions. And as a part of patent life cycle management and then patent strategy, that as an inventor, we develop a big library of the compound. And we wanted to go ahead and then patent it as early as possible, so that what is the invention which we have been done. So there will be a millions of compound. And through that particular journey, at some point of time, through, so you can say that the biological screening, we come to closer with a few compounds, probably maybe 100 or 1000 compounds, which are little bit better promising as compared with the plethora of the compounds which has been disclosed. And the further research which has been done to narrow down to the particular compound, which are more promising, and there has been a better chance to get through all clinical clearances, and then probably that may be approved as a drug. So this process is quite tedious and then continuous. So when we develop all library, we are not sure that which compound may be a good or which may be approved, because we have two thoughts. One is that protection of invention, and second, with the objective that we should bring something commercial, because it is written on investment. And we freeze down to those particular compounds that we can call it the narrower compound, wherein a specific few compounds out of the millions compound we go protection. So in pharmaceutical we call it as a generic and species. So first one is the generics, and then second one is the species. Yeah. So when it comes to the infringement, suppose we have both the protection, we have one broader patent which covers the plethora of the compound, and other subsequent species, that is the narrow class of the compound. So both covers the same compound. So when there has been any infringement, so both the patents which has been asserted against the generic or whosoever goes into the market. Okay. And there are two different ways basically, because that is from the enforcement perspective. And what Mr. Harris said, that when it goes to the prosecution, so the first prior art reference which has been cited against me is my own generic patent, because it covers millions of compound. And my argument, rebuttal argument to the examiner, I say that it covers the millions of compound, and person skilled in the art cannot determine which is the good compound. So I have done further searching, further research, and I come to with this particular compound. So there are two different ways, that in one way you are saying that it is not disclosed, and in other way you are saying that you are infringing my both the patents, because broadly it covers and then specifically it covers. So that's a very typical scenario generally we come across, because we have done a lot of I'm from VIATRIS, earlier it was the Mylan laboratory, and we are one of the pioneer into the pharmaceutical litigation. So not many litigations we have fought against the Pfizer or very big companies, and wherein we have tried to challenge those rules. But from US, Europe or all the developed country, they respect both the patents, and whether it is a smaller or specific patent or the broader generic patent, you are held responsible as an infringer in both the cases. But in India, the scenario is little bit because we were tracking some of the patent prosecution in India, wherein the generic patent has been cited as a prior art against the specific patent, and the specific patent are really struggling to get through that particular patentability. So these precedences are coming up, and right now the court is also considering, they are just differentiating that it is very broad one, and from the millions of compound, if you select a specific few compound, it is a selection invention, and the selection invention is also eligible for the invention, and that has been respected. But again, the patent office have an inconsistent decision, wherein we have been observed that in 3-4 very big pharmaceutical product, wherein such particular subsequent patent which has been rejected on the basis of the generic. So these are the challenges, but in outside it has been very well accepted. But again, the next question is related to derivative or other incremental part, then the section 3D and then other issues come into the existence.
I think Dr. Prasangi wants to say something there.
Added to Thakre, say, sir, in India also we faced the same situation in generic and specific, especially with the Ixaban as well as Enagliptin. They have both patents in India also granted as generic as well as specific. The almost all generic players has been faced the issues in the case of Ixaban. Wherein the case of Enagliptin also we filed along with the all other generic players, but the result has been came before expiring of 2 months. So here, as a generic manufacturing player, we always see it is covered in one patent. So the specific may not be granted. So we can't enter the market with a long aligning of all these patents.
Thank you. I think we have just time for about 2 questions. One question I'd like to ask Dr. Murthy again. Like I was prosecuting an application. It's a very funny kind of a situation. I can't name that client yet because the matter is sub judice. This was the case where I was prosecuting an application in India, and obviously it's an overseas company, and they were prosecuting applications in different parts of the world. It's a computer-related invention. So I had just finished arguing my case before the Indian Patent Office based on the Farid Aladdin case that my method is not a software or an algorithm, and it's a method with a technical effect. The Patent Office had promised that they will grant me a patent. I had to file a written submissions within 15 days. Within those 15 days, there was a US Patent Office action which said that your invention lacks in enabling disclosure because your invention requires an algorithm for this process to run. And since the algorithm is the integral part of the invention, and algorithm is patentable in the US, but you have not disclosed the algorithm, therefore the US patent is refused. Immediately, Indian Patent Office refused my application, saying that, oh, even the US Patent Office says that it's only an algorithm. So arguments are all wrong, so therefore we are refusing this application. So, have you faced a situation like this?
I have not faced such a situation, but I definitely want to comment on it. Because it goes to the heart of the patent system, which is quality, right? When the Indian Patent Office heard your arguments and when it agreed to grant you a patent, it was very, just because the US Patent Office said X, was it not evident to you while you were examining your patent application? If it was not, then it goes to the question of quality of your examination, right? And if the patent system is not able to deliver quality patents, then at some point in time there will be an attack on the entire system itself, the patent system, right? And not to save our jobs, but none of us want the system to go. It is a good system, right? So at every step, it is probably, I would not like to profess, but it is everybody's responsibility in the profession to focus on quality, right from the stage of invention up to the grant and up wherever it goes, right? I would turn back and ask, Algorithm could be one part, but there are several other parts of the invention which could stand the test of patentability.
Yeah, so therefore I'll conclude this by giving an answer by what really went wrong. Why? Because I asked this question because the role of this gentleman sitting over here, all of them, is so important when they are handling multi-jurisdictional applications. This was a small US company, and they did not really have someone in-house overseeing everything that's happening all over the world. So while I was arguing this application very strongly on the ground that the method is based on the technical effect and it's not algorithm based only, although algorithm may be used, the US attorney argued very strongly that it's a full set of algorithms, and that's where the inventive step resided. So therefore, the prosecution history is stopper of your own matter, depending upon how you call it. Sometimes you may actually say the same thing, but like I said earlier in the morning, half a glass of water can be called half full or half empty, depending upon your perspective. And sometimes the examiners or even the judges or human catch on to that. And I think we have reached a stage where every invention, I know that 40 years ago when I was applying for patents, prosecuting application, there were too many litigation. Now the market is very crowded. You know, the world has shrunk, the barriers have disappeared, and the patenting is a very serious business. One is for your own protection. Lots of companies also like to have defensive patents, because it's not because they want to really use those patents for their benefit, just to make sure that they create a barrier for a competitor to enter their space, which could then, be serious threat for you. And of course, you have the disruptive technologies happening all over the place. There's so many new technologies come, which completely, kill your earlier technology. Like a classic example is when I started using my computer, you had floppy disks, and then you had the CD. Now you have a flash drives, and I still remember my flash drive, 1 KB flash drive was the size of a brick. Now you can carry a tiny flash drive in your pocket. God knows how many TBs of data in there. Yeah. So, and they render the previous technology completely redundant. So I think we all have incredible amount of experience and knowledge in this field, enough to know that we are only in the beginning of the whole learning process. There's so much to grow as the technology keeps growing, and so much of evolution of law will take place. And I think these kind of discussions, these kind of seminars are so important for people of your caliber and expertise meeting together and discussing and sharing knowledge. Thank you very much for being here.
Thank you.
Actually,
thank you, Mr. Subramaniam, for moderating and getting the best out of the panelists.